In just a month's time, the public will have an opportunity to vote in the children's referendum. It is legislation that supporters say will go a long way to right the wrongs of the past and protect the interests of children. The publication of the wording for the referendum was broadly welcomed, with opposition parties and campaign groups signalling they would also be calling for a yes vote. But there are some critics who think it goes too far, including Cathy Sinnot, chairman of the Hope Project, who joins me from Cork, and Olivia O'Leary, journalist and board member of the Campaign for Children, who is here with me in studio. Cathy, good morning.
Good morning, Pat.
And Olivia, good morning to you.
Morning, Pat.
Cathy, we'll start with you.
Morning, Cathy.
Tell us why you are concerned about the wording of the referendum. Although maybe I should ask you a first question, which is, do you think that the intent behind the referendum was okay, but they got, if you like, the mechanics of it wrong?
No, I think it's a very cynical exercise. I don't think the intent, the only intention anyone should have when it comes to children is for their safety and their welfare. And I don't think, though many people innocently support it and do have that intent, I don't think that the drafters of this are among them.
But you don't think they're malign, do you?
I think it's a very cynical exercise, and I think when you go through the legal language here, which reduces the protection for children and severely limits the obligation the state has to help children, I think it's a very cynical exercise.
Who do you think was driving this cynicism? After all, we had the committee report, and then we had Minister Francis Fitzgerald kind of working very hard trying to get consensus and then publishing something that did get a broad welcome. So who are the cynics?
Well, this goes way back. I don't think you can understand the referendum we're facing probably next month without going back to where the call for constitutional change in the area of children came from. And it's been coming from the UN Committee on the Rights of the Child ever since Ireland ratified the UN Convention on the Rights of the Child 20 years ago last month. And Francis Fitzgerald has said that when Judge Juho Flaherty recently said that we don't need this, we need to cherish the children. The government has gotten that wrong, but we don't need this to do it.
What is wrong with the UN's ambition?
Well, Francis Fitzgerald at that stage said people have been calling for a change in the Constitution for 20 years, but she didn't tell the whole story. It isn't Irish people. It's the Committee on the Rights of the Child in New York that have been demanding that our Constitution be changed for the full implementation of the UN Convention on the Rights of the Child, which contradicts our Constitution.
What bad things are in there that you don't like?
Well, it's a combination of very good things and very bad things. The very good things we already have in our Constitution, the inherent and imprescriptible rights of the child. A child must be loved, it must be fed, it must be sheltered, a child must be educated, etc. There are some very, very problematic principles in it, and the main one is that it is the state and not the parent that decides the best interest of the child. There's also a lot of problems around the new freedoms. When we talk, or the new rights of the child, when we talk about the rights of a child, we talk about things like being fed, being loved, being nurtured. But when you go in, the extent of the rights of a child are very different in the UN Convention. They also extend to things like a freedom of expression, freedom of privacy, specifically including from their parents. Things like this. They're called freedom of thought, conscience and religion, freedom of association, privacy, association to information expression. Now, they all sound great, and parents constantly work to help their child develop freedom in these areas, but they do it, knowing their child and with their child's maturity.
Now we come to the nuts and bolts.
But when the state takes over, ensuring that
we'll come
there's
to the nuts and
problems.
bolts of our proposed new Article 42A in a moment. But Olivia, would you like to respond to what Cathy's been saying?
Well, the fact is that the United Nations Convention on the Rights of Children, it's been ratified, but it's actually not as important as the Irish Constitution. The Irish Constitution will always preside over the rights of the
Okay,
UN Convention
let's try
on the
and
Rights of Children.
dispatch that
So
first.
can we just, the UNCRC has nothing to do with this amendment.
Kathy,
it's not in here.
Kathy,
That's-
you have
yeah.
just, according to Olivia,
Yeah.
introduced a red herring.
No,
Hang on, let me just ask you the question. Do you accept or not whether the Irish Constitution is paramount? In other words, it's the essential document and everything else has to be subservient to it.
Yes, and that's why they want to change it. And that's why the UN Committee on the Rights of the Child has been demanding these very changes for 20 years. And it alarms me that people like Olivia, who I have great respect for, it alarms me that TDs are refusing to see the connection between the UN Convention on the Rights of the Child. And I'm not making this up. At least the Children's Rights Alliance, if you go on their website, are making the connection.
Okay, but hang on a second, Kathy.
I dealt with
Kathy,
this in Brussels, where it was directly
hang on a
the
second.
legal base.
You have accepted that the Irish Constitution is paramount, so we therefore will have to go into the wording of the referendum in our discussion to see in what way it drags in the things that you are fearful would come from the UN. But I want to ask Olivia, first of all, it's unusual, if not unprecedented, for you to be involved in a political campaign. Why did you decide to get involved rather than be a pundit?
I'll do what politicians do. I'll answer that question in a second. I just quickly want to say nowhere in the wording of this amendment does it mention the United Nations Convention on the Rights of Children. And secondly, we have a dualist system in this country where the courts have to interpret Irish law in line with the Convention, but it hasn't been taken into Irish law. You can't hold the state to its obligations under the Convention in Irish courts. The Irish Constitution is supreme. Now, to answer the question that you've asked me, you've asked
come
me.
back to you in a second, Kathy, because we'll deal with the wording in a moment. But why did you decide to get involved in this?
It's the first time in my life. I'm 63 years old, and it's the first time in a long journalistic life that I have stepped off the fence, so to speak, worn the badge. I've never done that, and I don't know that I ever would again. But I just feel very, very strongly that we need to put into our Constitution, specifically, the rights of children. About 30 years ago, I did a series on adoption, and it was then that I discovered, for instance, that the children of legally married parents almost cannot be adopted. It's almost impossible for them to be adopted. And yet, 30 years has gone by without our changing that situation. How many childhoods have been blighted? How many clouds have hung over how many childhoods? Because we still haven't put into the Constitution specifically the rights of children and allowed for the adoption
you were
of the
talking
children
about,
of
just to give,
legally married
to get
parents.
an understanding of this, you're talking about, say, people who've been fostered because their parents haven't cared for them for maybe 10 years.
Exactly.
They cannot ever be adopted at the moment under the law.
It used to be the case that they ended up in institutions. At least these days, most often, they're in foster care, which at least allows them the experience of a family. But they're caught between the family who want them and the family who can't care for them. It's unconscionable that we allow that situation.
Kathy, do you want to respond to that ambition, at least for this amendment, might be worthy?
I think if you look at the whole area of adoption, I think you're going to be quite surprised. I mean, in the second last quarter of this year, or the second quarter of this year, which is the last one we have figures for, there were 12 domestic adoptions. Now, there were thousands of children available for adoption, or thousands of children in foster care. 12 domestic adoptions. The problem was not whether or not their parents were married. The problem was that, and I won't say problem, the reality is they are still connected to parents. You can adopt a child of a married parent. No, there were only 12. There were only 12. Now, the thing is, it's not like there are a lot of adoptions and only the children of married parents are being left behind. A child of a married family can be adopted if there's been abandonment. The fact is, many of these children have been taken from married parents. Many of these children are still very much connected to their married parents. And what this is introducing is forced adoption. And this also applies to unmarried parents. Many of them have had their children taken from them. They're in foster care. What this will allow for the first time, like in the UK, is that children will be able to be taken and be forcibly adopted from unwilling parents, connected, bonded parents. And that's what this is about. And I think anyone who thinks that's a good idea should look in the UK, which is the other country that has this system, and see the incredible abuse of that.
Pat, can you imagine Irish judges conscious of Article 41 of our Constitution, which so copper fastens the rights of families and the fact that the presumption is that the best position for children is within families? Can you imagine Irish judges allowing whole-scale and mad and random adoption of children? It simply will not happen. Article 41 still guarantees the rights of parents and says that the presumption is that the best place for children is within families. We are only talking about a tiny, tiny percentage of vulnerable children who end up in a situation where either they're not allowed to belong to a family or they are being neglected or abused. It's a tiny percentage.
Kathy, before you answer that, I want to read out the section, because a lot of people haven't read it in truth.
People must read it.
Let me read it so you can comment on it.
They also must read what is taken out, what's deleted, because that's very, very important.
What is the proposal for part of Article 42A? This is paragraph 2. In exceptional cases where the parents, regardless of their marital status, fail in their duty towards their children to such extent that the safety or welfare of any of their children is likely to be prejudicially affected, the state as guardian of the common good shall, by proportionate means as provided by law, endeavour to supply the place of the parents, but always with due regard for the natural and imprescriptible rights of the child. Then it goes on, 2, provision shall be made by law for the adoption of any child where the parents have failed for such a period of time as may be prescribed by law in their duty towards the child, and where the best interests of the child so require. 3, provision shall be made by law for the voluntary placement for adoption and the adoption of any child. In other words, that parents who just simply can't cope, maybe a parent or parents can say, we can't cope, we want to put one of our children up for adoption, that the state will allow that to happen where heretofore it has not. So Kathy, your issue with those provisions?
Okay. First of all, you have to see what we're taking out to understand the difference in what we're putting in. In the Article 42.5, which we are deleting, and I love this article because I use this article to win the rights that for education for a child. This was part of the case, and it was part of the case that I, as a parent, had been entitled to help with my child. Okay, so it's a very important, and you cannot understand what they're putting in without seeing the amazing loss of Article 42.5, because in Article 42.5, it also talks about exceptional cases. Now, in the Irish, it's more uncommon cases, where a parent for physical or moral reasons. Now, what does that mean? It means where a parent for moral reasons, that is abuse, neglect, things that are the parent's fault. Mm-hmm. But it also says for physical reasons, and these are for reasons that are not the parent's fault. Things like the parent is sick, or the parent has a disability, or the child has a disability, or they're homeless, or they're poor. You know, that where parents fail, with the idea of they can't meet all their child's needs. They fail to meet their child's needs. The state, as guardian of the common good, by appropriate needs, and I can tell you the state has spent hours at taxpayer expense to fight the word appropriate, because that's really puts resources where they're needed. By appropriate means, they endeavour to supply the place of the parent with due regard to the natural and prescriptive.
And you don't think that what's been put in is the same?
What that means, if I can just explain very quickly, what that means is where a parent is a bad parent, damaging their child, the state does the appropriate thing, separates them, finds some loving person to take care of them or whatever, and puts the parent in jail, right? But where the parent is not at fault, either because of the condition of the child, the condition of the parent, or a social condition like poverty, the state must, by appropriate needs, assist the parents.
Okay, so it's the absence of that you're complaining about.
Completely missing.
Olivia.
There is no obligation.
Let me talk about the fact that this is an extraordinarily moderate amendment. All you have to do is to look at the widespread support for it to realise how moderate it is. It uses phrases like in exceptional cases before there's any intervention. It uses phrases like proportionate means before there's any intervention. And I think what we have to remember here before we get lost in legalese is that we have had report after report after report, the Kilkenny incest case, the Kelly Fitzgerald case, very strong, the Roscommon case, telling us that the voice of the child isn't being heard and must be heard, and that this constitutional case is necessary. There's hardly any one of us who wasn't ashamed when we saw the results of those reports and who asked ourselves, what can we do to make the voice of the child heard? We can do it by going out on the 10th of November and putting into the Constitution specifically the rights of children, because we put what we value into the Constitution. Let's put specific rights for children.
Can you address what
into
Cathy
the
said about
Constitution.
what's taken out? That she actually used that provision in order to try to force the state to do something for people.
Successfully force the state.
That's what you were trying to do, and you succeeded.
Listen, successfully forcing the state to do things for children will actually be strengthened by this particular amendment.
No.
Because there is now a constitutional imperative which says that the best interests of the child shall be the paramount consideration. That is going to affect every interpretation of the law. It's going to affect a whole attitude. I mean, the fact of the matter is, people go on about the state, the dreadful state. Yes, the state has made mistakes, but this change in the Constitution allows us to start laying the foundation for a proper family support and child protection system in which the best interests of the child are paramount, and equally important, that the voice of the child is heard.
In this particular case, which is paragraph 412, concerning the adoption, guardianship or custody of or access to any child, the best interests of the child shall be the paramount consideration. I mean, that's to do with access and adoption and guardianship and so on.
Yeah. But why would anybody object to the fact that the best interests of the child should be the paramount consideration?
That's fine. I'm saying that may be fine. If you're going through that process, the fact that the child's interest should be paramount is logical. However, what Cathy is saying, in other areas, the areas of disability or parents' physical incapacity, that bit that she had in Article 41, is that it? 42.5 is gone.
But the fact of the matter is that
and
this strengthens the rights of children, as well as keeping the rights of parents.
No.
It's actually going to strengthen anybody who, for instance, wants to litigate in terms of the best interests of children. It's now going to be in the Constitution. That specific guarantee to children we are now putting in the Constitution. And the fact of the matter is that in Ireland, and in most cases, parents are the best defenders of their children's rights. So most parents will be actually delighted at the fact that this gives them the opportunity.
We heard Cathy's objection, 42.5, right? Can I offer you this one, Cathy, just to see, does this in a catch-all way cover your objection? And that's the very first sentence in the amendment of the proposed new Article 42A. The state recognises and affirms the natural and imprescriptible rights of all children and shall, as far as practicable by its laws, protect and vindicate those rights. Does that not cover the situation that you found yourself in?
No. In fact, I have many problems with this. I've only told you one. But no, in fact, that's weaker than what we presently have. At the moment, the state must have due regard to the natural imprescriptible rights of the child, blank. In the new one, they only have to as far as practicable. So it already weakens it. No, but the thing is, you've said a lot of things. One of the things that people must be very, very clear on, you can't say, oh, this is just legalese. We discard legalese. The thing about every word in a constitution is it gets weighed, it gets measured. People's fates depend on exactly what the word says, where it's placed, what context it's in.
Olivia.
When you say the best interest...
It gets weighed and it gets measured. And that's why it's important that it's in the Constitution that we say that the state recognises and affirms the natural and imprescriptible rights of all children. I mean, I'm
Which is
actually
already in the Constitution.
enormous. No, it's not.
It is. It's right
not.
there. I'm looking
it's
at
not.
it.
The
Article
state
42.5.
Children's rights are not specifically mentioned in that form.
Olivia,
there is an
alarming.
implicit
I'm
amount of
looking
rights
at
given
the
to
words.
children. But the reason
Olivia.
that this amendment is going in is that there has not been the same
Olivia.
statement of the rights of
Olivia.
children as the rights
read
of parents.
42.5 again.
Olivia, I'm looking at the words. The Sinnot case would not have been won except that children's rights are in the Constitution.
Read
and
it
are
for us,
explicit.
Cathy.
Okay, this is what we're taking out. In exceptional cases where the parent, for physical or moral reasons, that means fault or no fault reasons, fail in their duty towards their children, the state, as guardian of the common good, by appropriate means, not proportionate. Proportionate has a view to budgets. It's a European term of proportionality, as much as they think they can spend. By appropriate means what the child needs, means shall endeavour to supply the place of the parents, but always with due regard for the natural and imprescriptible rights of the child.
But it isn't stated as formally as it is now
It's
going
as
to be
formally
stated.
as it can
no,
be stated.
It's this we now have in 42A, an explicit and very strong statement
Yes,
of the
which
rights
is then-
of the child.
which then
and
gives the
that
state-
is important. And
No,
the
no, no,
reason
no, no,
let
no.
me finish,
Which
Cathy. Please
then-
Okay, Cathy,
please let me
please,
finish.
okay.
If the rights of the child were stated adequately, as Cathy suggests, why would report after report after report into the dreadful abuse and neglect of children state that the Constitution needs to be changed so that the voice of the child and the best interests of the child need to be heard? How many more reports do we need telling us this before we do what we should and change the Constitution to put into it what we value, our children and their rights?
Olivia, listen. Not only are the same phrases in both versions, but in the new version, the state gets the get-out clause of as far as practicable, which they don't have in the first one. But yes, I'll answer that. The reason the Kilkenny children suffered, the reason the Roscommon, is that the state, which was obliged to help them and protect them, did not do it. Now, I have a High Court judgment, most of which is upheld by the Supreme Court, on that very issue of profound damage to my son from state neglect. The biggest neglector of children in this country is the state. Absolutely the state. This, in several places, lets the state off the hook, but puts parents on a normal, good, loving parents on the spit. And you say, and
Olivia?
if you
No,
don't understand, it absolutely does.
It doesn't do any such thing. Let me
It
repeat.
does.
Article 41 continues to copper fasten the rights of parents and to say that the best place for the child is within the family. I do not disagree with Cathy that the state has failed on many occasions. And the reason that we need to put this particular phrase into the Constitution is that we need a solid foundation within the Constitution to allow us to build a proper system of family support and child protection. And what better way to do it than to specifically state the rights of the child?
But Cathy, a lot of this will depend on the interpretation of the courts in time when someone takes a case. If the state, for example, has removed a child from its natural parent or parents and puts that child up for adoption and someone objects, are you saying that you don't actually trust the courts, you don't trust the legislature in the first place, but you don't trust the courts to make a fair decision? Is that really where this is coming from?
Well, it's not where it's coming, because I've already worked on legislation around children's rights in Europe and around the UN.
But you know what I mean? That this will end up if there's a row, it'll end up in the courts.
Of course.
And do you trust the courts to actually make an appropriate decision?
This, in fact, makes it inevitable that ordinary situations in good families will wind up in the courts, because it pits parents against children. And I would remind you of what Emily Logan has said, that in all of her time as ombudsman, she's never had to deal with a case where there was conflict between the rights of parents and children. And yet this will pit those rights together by giving new rights to children that a lot of parents, you know, in their wisdom are going to know aren't good for children at certain points in their life.
To put a practical gloss on this, Kathy, you've got, say, a family of drug addicts and alcoholics and so on who are abusing a child.
Well, you know,
I'm being extreme now. So
let's be extreme.
The state moves in, and most right-thinking people say, thank God that someone's saving that child from perdition. What would your view be in that situation? Should the state go in and take that child?
The state has an absolute obligation to go in and protect that child, whatever it takes. It has always had that obligation. We have an incredibly negligent state. And I'll just put this to you.
Has it therefore got the right
to
extend the happiness of that child to being embraced by another family?
Yeah, but
permanently.
You know something? Let's look at the UK, how it really turns out in the end. The UK has about 2,000 forced adoptions a year, right? 2,000. 1,700 of them are now judged by MPs like Hemming, and this is a scandal being highlighted by people like Bob Geldof and Christopher Booker, are being seen as absolutely fraudulent because it isn't children in care, children who have had a terrible background of suffering that are being adopted. It's babies.
And
we have this.
And parents, Kathy, let me in here,
No.
please. The rights of children and of parents conflict only where there's a case where the best interests of the child aren't being served and where there's a case of neglect and abuse. Now, what this allows for is that the best interests of the child will be served. That's surely what we want, and that's what this amendment allows for.
No, under the current amendment, that's the position. That it's a very clear obligation which the state has not kept, a very clear obligation to protect children from all forms of failure that's the fault of the parents and failure that isn't.
Kathy,
but
I'm just getting back to this. I don't necessarily want to use the UK as a template because this is Ireland. The UK is the UK. We will do our business the way the public vote in this referendum for or against. But, you know, our courts will be preeminent in any constitutional rows. So the UK experience may not be applicable here.
Oh, it's absolutely applicable. I mean, I had no idea. I knew what was going on, the kind of damage and neglect going on in the special needs area before I was an MEP. But once I became an MEP and constituents started to come to me about what was happening in the in-camera courts, I have been in the in-camera courts. I have seen breastfed babies stolen from their loving mothers. I have seen these things.
Kathy, please, please. I hate to see you using that sort of language, particularly when we're talking about children. This is a moderate document which is going to put into the Constitution the rights of children.
Well, if you don't know what's going on in our in-camera courts, then
there is no reason for most parents to be scared because there is nothing in here that actually in any way threatens them. What this amendment does is that those vulnerable children, that small group of vulnerable children about whom we all care desperately, will now have a voice. They haven't had a voice before, and those who abuse and neglect them perhaps don't want them to have that voice.
Olivia.
No parent, and this is most parents who care deeply about their children and are the best advocates for their children, will object to the notion that the best interests of the child shall always be paramount. And that's what's being put in the Constitution. And that is a real value that we should all be proud of.
Olivia, the protection of children is too important to allow you to get away with that kind of fuzzy thinking. The best interest of the child is not a warm, fuzzy phrase. It's a hard, legal principle from the UN Convention on the Rights of the Child.
And here's a hard legal document that puts it in hard legal words.
Yes, and what it says is that it's the state that decides, not the parent, what's in the best interest of the child. And in the new wording, wherever it comes to the responsibility of parents, it's in the best interest of the child, which means that the state decides what the parent should or should not be doing.
Well,
Article 41 remains
state,
guaranteeing
we're
the family.
going
Article
round in circles at
41
this
remains.
point. Kathy Sinnot, the chair of the Hope Project, thank you very much for joining us. Olivia
Thank you.
Leary, member of the Campaign for Children, thank you also. Running a bit late, we'll have news up after this break.